Item number 33.
Yes.
All the defects which are curable by me, I procure
Some defects even to go to the trial court.
my lord.
But the other defects, it has to go back to the trial court.
Yes, my lord. My lord, initially the primary issue, my lord, involved in this appeal, my lord,
Yes.
amongst others,
Yes.
whether a parta whole property or trust property can be declared as a absolute ownership right.
You are the defendant or the plaintiff?
I am the defendant and appellant here,
You lost in both the courts.
my lord.
Their suit was for declaration of title.
No, they are sued directly, my lord, sued for eviction.
You are a trespasser.
I am the co-beneficiary of the property, my lord. I am the, my lord, daughter. I am the son of daughter of
What
the
is their-
original refugee family.
What is the plaintiff case? That you are a trespasser or a licensee or what?
No, they are saying, but the trial court holds that I am a licensee.
What is the plaintiff case? What is their case?
The plain case is that, my lord,
You are a trespasser or licensee or
licensee.
licensee?
Yes.
Very good. What was your defense? Now tell us.
Now, my lord, fact is required to be, my lord.
Fact means your defense.
Yes, my lord. I'm
Your fact is your defense.
Yes, my lord. I'm saying, my lord, one by one. My lord, initially the fact is, my lord, initially my grandfather, Rai Kishore Rai, came from the East Pakistan. Thereafter, my lord came from the East Pakistan with, my lord, 3 sons, including the father of the respondent and my mother, and 5 daughters, including my mother. Thereafter, my lord, after coming from the East Pakistan, the government by the scheme, my lord, started to process, my lord, rehabilitation. But in the meantime, in the year 1975-76, my grandfather died, my lord. In his absence, my lord, the patta was issued in the year 1989 in the name of father of the respondent, being Korta or head of the family, who shall hold the property, being trustee for all the beneficiaries. Now, my lord, the position is that after the death of the father of the respondent and after death of my mother, we, the respondent, appeal are the co-beneficiaries. Now, my lord, one government order is very necessary to.
Your mother was married at the time when the patta was given.
No. Now, my lord, they are claiming the right from their father, and I am claiming the right from my mother.
They are claiming exclusive right.
Exclusive.
But
right.
you say that patta has to be held by his father on behalf of all the beneficiaries.
All the beneficiaries.
How was it dealt with by the court? Why was your plea turned down?
Yes, my lord.
Appears to be the law. What you are saying appears to be the law. How was it turned down?
Now, my lord, before my lord going to the, my lord, court order, the impugned order, my lord, I want to rely on the kindly, my lord, comes to the what is the scheme is saying. What is the scheme is saying? It is a special scheme, my lord. My lord, kindly come to
Refugee rehabilitation scheme says it will be held by on behalf of the others. Well, let us see this scheme.
My lord, the page is, my lord, 77 and 78. It is, my lord, the document which I can, my lord, collect, the type copy is next page 79. But I am reading, my lord. May I read, my lord?
Yes.
The undersigned, it is a, my lord, 81 government order. The undersigned is directed by the order of the governor to say that as a measure of rehabilitation of displaced families, homestead plots where are being allotted to the GS colonies or squatting in approved squatters colonies where are being regularized with the clear indication that the beneficiaries of the allotment will be all the members of the family on record, though the allotment order was issued in the name of one member of the family as karta or de facto head of the family, who might have been the eldest brother or else as per composition of the family as recorded at the time of allotment of the plots. Now, my lord, although the allotment could not and cannot be made to a family in the abstract sense, it follows and it is confirmed that the allottee in a case obtained the allotment order on behalf of the other members who are shown as a comprising family. My lord, thereafter, my lord, after filing this, my lord, appeal, my lord, I made an, my lord, RTI application to the department. I am handing over the copy to my other.
No, new document.
But it is necessary because, my lord, kindly realize.
We cannot look into new document. Sorry. If you do
in this document, my lord,
might have been, you have to file a regular order for 27 wants to admit it. We cannot just look into that.
Yes. Now, my
It's
lord,
not a writ petition. In a second appeal, we cannot just look into documents.
now, my lord, if my lord kindly come.
So, how was it dealt with by the courts below? Let us see the appellate court.
Trial court order, my lord.
No, appellate court.
Appellate.
The judgment of affirmance, let us see.
Appellate court order for starting from 43 page of my lord state petition. Now, my lord, kindly come to the page 40, page 46 of my stay application, my lord. The last paragraph, 1, 2, 3, third paragraph. My lord, may I read, my lord?
The internal page?
Internal page, my lord, 3.
Of the appeal court?
1, 2, 3, 4, my lord.
At the bottom, you find the page number.
Yes. 2, 3, 4, my lord, 4.
Yes.
4, my lord, third paragraph.
Yes.
It is against the decision of the trial court as mentioned above. The defendant appellant preferred this appeal on the ground that the trial court did not apply judicial mind and failed to appreciate the evidence and material record. The learned trial court failed to appreciate that even if the deed of gift was executed, but a deed of gift is executed by the father of the my lord, defendant to me, but it is my lord, admitted it was unregistered. Because my lord, I am residing with my uncle, that is mama, that is father of the respondent from my childhood, my lord. I have constructed therein, my lord, my construction. I have mutated properly, my lord. The deed of gift was executed in the favor of Niranjan Kumar Roy, that is their father. Being the father of the respondent and their predecessor interest hold the property in the suit as a trustee of the entire family as per notification of the, that is the geo, my lord, which I have realized. So, my lord, I have asked the geo, my lord,
on the basis of that gift deed, the appellate court proceeded on the premise that as if you have admitted their title and
no, they are, my lord, in the after filing the suit, they have, my lord, objected the gift deed. But it is the gift deed which is given in my favor, executed in my favor, though it is unregistered. My lord, gift deed is appearing at page number, my lord.
Not that. The appellate court proceeded on the premise that the gift deed is unregistered, that's why you don't acquire any
title. Yes.
But by accepting that gift deed, by producing that gift deed, you admitted his title because one having title can only give a gift.
Yes.
That was the premise on which the appellate court
proceeded. But my lord, the same cannot, my lord, bypass the statutory provision.
You are right. This appeal will be heard on the following substantial questions of law. One, whether the courts below proceeded on an erroneous premise, by overlooking the relevant government order number 2492/17 hyphen rehab, Arta capital, to capital P P for partner, hyphen 82/79, dated April 23, 1981, in holding that the father of the plaintiff respondent acquired absolute title in the disputed property, despite the settled law that in schemes for allotment to squatters, refugees, the allotment made in favor of the head of the family is deemed to be on behalf of all the other members of the family. Next, Roman 2, whether the courts below failed to adhere to the well settled legal dictum that there cannot be any admission against the law, inasmuch as the government order dated April 23, 1981 has the force of law, and merely by admitting the execution of a deed of gift by the predecessor in interest of the plaintiff in favor of the appellant, the appellant did not, the appellant could not be precluded from challenging the exclusivity of the title of the said predecessor of the plaintiff, namely Niranjan Kumar Rai. Any interim application?
Yes, my lord, stay application, my lord, is there, my lord, stay, praying for stay of.
Yes, what do you say in the stay application?
Lord, may I only invite your lordship's attention to page 51 and 52 of their three applications. Because this is where this objection has been dealt with by the Lord appellate court below.
Maybe
That is why
we'll hear the when we hear the appeal on bench, we'll hear.
because our
What
execution
about
has been already filed, my lord. And
you have given the number?
I remember the number is, my lord, I have stated by the para 33 of my application, miss case 50 arising out of TX number 1 of 23.
In your stay application, you have not paid for stay of execution. Yes, you have paid.
Yes, my lord.
In view of the appeal having been admitted by on substantial questions of law, comma, a sufficiently strong prima facie case has been made out. Accordingly, there shall be stay of all further proceedings. In what is miscellaneous case?
Miscellaneous case 15 of 23.
What is that under which provision?
My lord, execution.
Execution is title execution case number. What is the miss case?
My lord, sir, time, my lord.
Yes, can you tell us what is the miss case about?
I am not informed.
Very well. That execution is taken. Stay of all further proceedings in title execution case number 1 of 2023 pending before the court of the learned civil judge junior division at Vidhannagar district North 24 Parganas as well as all connected proceedings till disposal of the appeal. So, can 1 of 2025 can 1 of 2025 is allowed. The can 1 of 2025 is accordingly disposed of without any orders to cause. So, in view of the appearance of the you are appealing for both the response. In view of the appearance, you lost the caveat. In view of the appearance of the plaintiff's respondents by dint of caveat, comma, service of notice of the appeal on the said respondents is dispensed with, and the Vakalatama file in connection with the caveat be deemed to be the appearance of the respondents in the appeal as well. So, next para, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the record within 6 weeks from the date of service of notice of the appeal on the learned advocate for the appellant. First up, liberty to the parties to mention the appeal before the appropriate learned single judge, then having determination for inclusion in the list as and when the appeal is ready for you. The records be sent down to the trial court in the meantime. Archana, the decree of the certified copies of the impugned decrees be sent down to the trial court in the meantime for the purpose of correction in terms of the additional stamp reporter's report. Sorry, we did not hear you, but in second appeal, normally don't have a right of hearing. Because you are taking us to different documents, we cannot look into that at least. Take up the next matter.